In my last video, I explained how foreigners can legally buy property in Thailand. I covered freehold and leasehold. Simple breakdown. But after that video went live, I got feedback from lawyers who specialize in Thai property and law, and they pointed out something important. I gave you what developers say about leasehold, but I didn't explain what Thai law actually protects. Big difference. So this video is the correction, it is the nuance, the transparency behind the marketing. Developers tell you 90 years, 330 years locked in from day one. That sounds great, but here is what actually happens in Thai courts and what the 2025 Supreme Court ruling changed. This is the video that separates what sounds good from what's actually enforceable. And if you're committing serious money to a 30-year lease, you need to know the difference. And let's go. What developer actually says versus the reality. Let me show you exactly what changed. Here's the marketing pitch. Leasehold in Thailand is 30 plus 30 plus 30 years. That is 90 years. Basically, you own it. Here's what Thai law actually says. You have 30 years. That is legally guaranteed. The second and third 30-year blocks, they are written in your contract, but they are not automatically binding under the Thai law. This is the difference between what sounds good and what a Thai court will actually enforce. In March 2025, literally less than a year ago, the Thai Supreme Court ruled out on this exact thing. Case number 4655 bar 2566. They said any lease promises that tries to lock you into 90 years from day one, it's void. It doesn't hold up in court, even if you signed it, even if you paid for it. Why does this matter? Because if you bought a property with a 30 plus 30 plus 30 year renewal guarantee, those last two 30-year blocks are legally hollow. The developer can't be forced to honor them. You have 30 years of real protection. After that, renewal is negotiation, not a right. That's what this video is about. Making sure you understand what you actually have, not what someone sold you. Let's try to understand why this law exists. Now, here is what most real estate guys won't tell you. This law didn't come out of nowhere. Thailand didn't just randomly decided to cap the lease at 30 years. There's actually a history here. Back in the 1970s, the country was trying to fix itself. Thailand had a massive problem. Tenant farmers who worked on their land their entire life. They almost had no security. Powerful landlords controlled huge plots. Farmers paid unfair rents. No protection, no path to ownership. It was feudal, literally. In 1973, when the military government fell, political space opened up, and thousands of farmers started organizing protests. They marched on to Bangkok. They demanded fair rents. They demanded protection from landlords. They demanded not to be trapped in a system where one person controls the land forever and they just work on it. The Thai government listened because they understood something. If you don't control how land is leased, you end up with two classes: people with land and people without it, and that breeds instability. So in 1974 and 1975, they passed some laws. The Land Rent Control Act, the Agricultural Land Reform Act, and they kept strengthening the land policy since early 1990s and early 2000s. One core principle ran through all of it. Thailand's land won't be concentrated in the hands of few, and no one gets indefinite control without actually owning it. That principle is still embedded in Thai law today. So Section 540, the 30-year lease limit, is literally a part or a byproduct of these policies which shaped into this. Why am I telling you this? Because this law is not going to change. Thai government is not going to wake up one day and say, let's grant all the 99-year-old leases to foreigners. That would contradict 50 years of policy and betray a fundamental political principle. When you are evaluating property, don't bet on the law changing. Don't hope that Section 540 gets relaxed. Plan your investment assuming this stays exactly as it is, because it probably will. What Section 540 actually says. Let me read you the exact wording. Section 540 of the Thai Civil and Commercial Code. For immovable property, it is prohibited to lease for a period exceeding 30 years. If a contract is made for a longer period, it shall be reduced to 30 years. The aforesaid period may be renewed, but it must not exceed 30 years from the time of renewal. Let me break down what that actually means in practice. 1. You can't actually own land in Thailand as a foreigner. That's the Thai constitutional law. However, there are rare exceptions. I think there are some relaxation if you marry Thai national, but again, it's not fully owned by you. Some cases they allow to own lands in special industrial zones, but it's a whole different procedure depending on a lot of approval from the ministry. We are not going to discuss that in this video. But basically, no, foreigners can't own land in Thailand. That's the law. This is intentional. It protects Thai land. It's as simple as that. You have two legal options. Option A is leasehold. You lease the land or the building or the villa. You don't own it. Maximum 30 years, legally enforceable from day one. After that, renewable is negotiated. Option B is freehold condo. You can own up to 49% of a condo building outright. No lease expiration, permanent ownership. But Thailand keeps the foreign ownership up to 49% in a development. So 51% is local and 49%. So you can have 49 units in a development of 100 units, not the whole building. Make sense? So both options are legal. Your choice depends on the budget and timeline. 3. Any leasehold cannot be longer than 30 years from when it starts. Not 31, not 50, not 90. 30 years. 4. After those 30 years, renewal can happen, but it's not automatic. It's not guaranteed. It requires a new negotiation with the landowner. 5. Any renewal also cannot exceed 30 years. So theoretically, you could have years 1 to 30 first lease, years 31 to 60 renewed lease if agreed, years 61 to 90 renewed again if agreed. But those second and third renewals are not enforceable in the court right now. They are not binding from day one. 6. There is no exceptions. Every foreigner, every property, every developer in Thailand, same rule. If someone else promises you 90 years with whatever methods they have, they're trying to sell you something that won't hold up in the court. The 2025 ruling, what changed? Okay, here is the critical part. For many years, developers in Phuket had been doing this. They'll sell you a 30-year lease, but in the same contract or sometimes in a separate side agreement. They promise you 2 more 30-year renewals, guaranteed, locked in. Some of them will even take your money upfront for all the 90 years. The marketing was you basically own this for 90 years. It sounded great, but it wasn't fully legal. In March 2025, the Thai Supreme Court closed this loophole in case 4655/2566. Here's what they actually ruled. Any lease provision that tries to guarantee a term longer than 30 years from day one is unenforceable. Even if you signed it, even if you paid for it, even if both parties agreed to it in writing. Why did they do this? Because allowing guaranteed 90-year leases would turn Section 540 into a joke. It would mean that the law doesn't actually limit the leases, it just makes them inconvenient to structure. The court also said something important. After 30 years, circumstances change, property conditions change, land value changes, developers' financial stability changes. The law sets a hard checkpoint so both sides can renegotiate based on the reality, not a promise made on 3 decades earlier. That makes sense. What it means if you already own, if you bought it with a 30 plus 30 plus 30 years renewal guarantee in your contract, those last two blocks are legally hollow. A Thai court won't enforce them. You have 30 years, and after that, renewal is negotiation. What it means to you if you're buying now, any developer offering you guaranteed renewal beyond 30 years is either not reading the Thai law correctly or not telling you the truth, and that's a red flag. Now I know what actually keeps you up at night. Let me address 3 real scenarios. Question 1. What if the owner of the development or the developer dies or the company changes hands and the new owner refuses renewal? This can happen. Developer pass away, company gets sold, and sometimes new owner don't honor previous commitments. Here's the thing, your contract isn't with the developer personally, it is with the company. So ownership changes don't erase the obligation. But here's the reality, if a new owner doesn't want to renew, they'll find reasons. They'll say the building is too old, they may claim financial hardship, they may say that the landowner won't cooperate. That's where the contract matters. Does it require the developer to attempt renewal with evidence? Does it specify a refund if they fail to renew? If yes, you have a leverage. If no, you're hoping. I think this is why a refund structure is very important. It puts financial pressure on the developer even after the ownership changes, because if they don't renew, it costs them money. Question 2. What if they allow renewal but the price is 300% higher than before? It can happen, right? After 30 years, value changes, and they might say, sure, we can renew. That'll be 1 million baht per year, not 50,000. This is hypothetical. Thai law doesn't cap renewal prices. It doesn't say they have to be fair. So this comes down to what's in your contract. If it says renewal at rates not exceeding certain percentage, you have a protection. If it has a refund mechanism, if you don't renew us at a reasonable rate, we refund you. Suddenly the developer has incentive to be reasonable. Question 3. What if Thai government changes policy or shuts down all foreign leases? There is still a minute possibility that this could happen. Thailand has had political changes. You could imagine a government saying, for example, all foreign leases end in 2040. Leave. Honest answer, if that happens, no contract protects you. If Thai government changes the law, you're out. They have sovereign power. But here's the realistic probability that's extremely unlikely. Why? Because Phuket's economy runs on foreign investment. Construction, real estate, tourism, billions of baht. A government that invalidated all foreign property leases would destroy foreign investment confidence in Thailand entirely. Would they do it? Theoretically possible? Likely no. But here's what protects you against black swan scenarios. Diversification. Don't put all your capital into one 30-year lease. Have alternatives, have options. A mixed freehold with leasehold. If you own some units as freehold, you own them. No leases, no policy changes affects you. That's permanent. The honest truth, if Thailand invalidates foreign property ownership, no contract saves you. The honest probability that's not happening while Phuket depends on foreign capital. So plan accordingly. What actually protects your money? So Section 540 gives you 30 years of legal security. That's real. Thai courts will enforce it, but renewal after year 30 not automatic. So the question is, what actually protects your capital if renewal doesn't happen or you want to exit? Answer is smart developer structures. Responsible developers, the ones who understand Thai law and actually care about buyer protection, build explicit refund mechanisms into their contracts. Here's what you should see in writing. Year 30 arrives, you've been in the property for 30 years. Renewal process starts. Developer begins formal negotiation with the landowner, or most likely they are the landowner. So scenario A is renewal is successful. You sign a 30-year lease and you continue. Scenario B, renewal fails. Developer is contractually obligated to refund percentage of your original investment based on how many years you've been occupied. The mature developer structure looks like this. Your 30-year checkpoint, 75 to 80% refund. If renewal fails, you got 30 years of use, you would have earned ROI on that property. Developer's loss is minimal as well, so it's a win-win. Year 60 checkpoint, if renewed once, 50 to 60% refund, got 60 years, more equity returned. Year 90 checkpoint, if renewed twice, 25 to 40% refund, you got 90 years, minimal return. Why these percentages? Because you've gotten significant use. If you have rented it out, you would have made at least twice or thrice the property value in total rent collected. The developer returns a meaningful portion. Is it full capital return? No. But it means the developer has skin in the game. They are betting on renewal. They're not just taking your money and hoping. Red flags, what not to see in the contract. Complete silence on renewal. Renewal at developer's sole discretion. Vague promises like will attempt to renew, we hope to renew, or subject to circumstances. No refund mechanism at all. Refund only after you've lost 50% of the equity. Now, green flags, what to look for. Specific refund percentage in writing, if any, not verbal. Tiered refund structure, more money back earlier. Exact timeline for renewal process, specific dates when developer must start. Affirmative language, will notify, will initiate, must. Automatic refund trigger, not optional. Developer obligation to attempt renewal with evidence. Not every developer in Phuket has this structure yet, but the ones who do, they are signaling that they have thought about buyer protection, and that's worth noticing. How to evaluate a property. Here's your step by step when evaluating leasehold property in Thailand. Step 1, read section 540 yourself. Don't just trust what an agent tells you. Go to Thailand online, get a bilingual lawyer, read the actual law. You need to know what it says, not what someone told you it says. Ask the developer these exact questions. What's your formal plan for renewal after 30 years? Do you have the landowner's written agreement to renew? What happens if the renewal doesn't go through? What percentage of my investment do I get back in case if the renewal fails? Is this in my purchase contract? If you get vague answers, we'll figure it out. Probably, most likely, just walk away. Get the refund clause in purchase agreement in writing. Don't accept verbal promises. Get specific numbers, percentages, timeline, triggers, all in the contract. Have a Thai lawyer review it. Your lawyer, someone who specializes in foreign property purchase, someone who reads Thai contracts for a living. Have them specifically review section 540 compliance, refund mechanism, if possible, renewal obligations, your exit options. Understand your exit strategy. What if you want to sell after 15 years? Yes, you can. The new buyer steps into the lease with 15 years remaining. That affects resale price sometimes significantly. What if you sell after 25 years? Same thing. Fewer years left, lower market value. Plan for this. It's not a deal breaker, but it's real. Compare developers on their renewal commitment. Look at multiple developers. Compare their refund structures, if any. Compare their clarity. Developers who are clear and specific about renewal are signaling confidence. They have thought about this. They are betting on their ability to renew. Developers who are vague are signaling risk. That's it. You know more about Thai property law than 95% of the people buying in Phuket. I know this is detailed, but this is the detail that separates a solid 30-year investment from a property that looks good until year 29. I've spent my last decade in real estate in UAE, India, Qatar, Bahrain, Maldives, and Phuket. I've read thousands of contracts. I understand Thai law, closed millions in sales. I've studied the Supreme Court rulings, and I help buyers make decisions based on facts, not sales pitches. If you found this useful, subscribe. I post content every week on how to actually protect your money in Thailand real estate. If you're ready to talk about specific property, details are in my About section. Thanks for watching. Krap and krap.